overall question of transparency and procedural fairness. I'm not going to go into all of the details because of time, but to give you some ideas, and then I will focus in particular on the issues which Commissioner Artemenko raised. So why do we care about this? Procedural fairness and transparency it's not only fair to the parties, which is important, but it also leads to better results for us as an agency making these decisions. Our decisions are better informed. We are less likely to make a mistake by restricting good conduct that we want to see. And it makes sure that we are testing our ideas along the way so that we are not sort of going along by our own momentum. There's a lot of guidance out there on this by the ICN and to a lesser extent the OECD. Transparency can really appear in different levels. The agency standards and procedures at the investigative stage, the internal decision-making stage, at the adjudication stage, and at judicial review. It's particularly important to have the transparent procedures and standards. Not only the legislation and the rules and regulations, which I think everyone would agree with, and the agency's internal guidelines, which are transparent and posted on the internet, but in particular the explanation of the rationale for particular cases. And that really is the issue which we are talking about here. We have found that we are generally able to explain why we acted in a particular case in a way that does not reveal confidential information. And most of our decisions can say why we found that a particular sector is within the relevant market and which is not, without referencing the specific information. In unusual cases, there is some data which is confidential, and we then will have to black out a certain portion of it, which is then published on the publicly, and the confidential version is available for the courts to review. But that is a very small fraction of the information, and you can look at the two side by side, and there's not a lot of difference between the two. These standards are important for us then promoting what our standards are and what our procedures are and how we decide things in cases so firms can conform their conduct to it. And most firms want to do exactly that. So the way we do that is we have our top officials, our chairman make speeches. We put all of the records of cases on our website on the left. We have guidances were published. And even lower officials sometimes go out and make speeches like that guy in the lower left. At the investigative stage, one thing which I put at the bottom here is we want to confront the myth of secrecy. The idea that rationale must be kept within the agency. So there was a scene from a movie. I could tell you, but then I'd have to kill you. That's not the way we want to do it. We want to tell the public everything we can. One point in engaging with the parties, we have a regular dialogue with the parties to a case from the very beginning to the end. Phone calls with counsel every week, sometimes every day. We tell them from the very beginning what it is that's on our mind, what is it that concerns us. Is it the relevant market? Is it whether entry is possible or not? And that way they can focus their arguments on what we're concerned about and not wasting their time and ours by providing information about things which we don't see as being a big issue. They may submit both oral arguments and written arguments to us at every stage of the agreement, and we will take them seriously. And these discussions help us focus our investigations. It lets us sharpen our own theory, and it lets us test our own theory. If we have an idea about what's a competitive concern and we hear what the other side is, it might make the concern go away. It certainly will tell us what the issue that we will have to face when we ultimately go to court. And then if we have a chance to test that, we won't be pursuing ideas that don't pan out in the end. Significantly, it also lets us focus our document requests so that firms are not producing documents which cost them money and we'll never have time to look at. Okay. So I want to move ahead to the protection of confidential information because we do have to both protect business and confidential information for the reasons which are stated. We have to respect the applicable privileges, such as attorney-client privileges, and yet at the same time, we have to be able to give firms the information they need so that they are able to respond to our concerns, both to us at the adjudicative stage and ultimately in court. And so we have procedures in place. We can issue protective orders, which says that we will disclose information to the firm's counsel so that they can defend themselves, but they are ordered not to disclose it further. When companies come to us and say this information is confidential, that's their assertion, but the agency ultimately makes the decision. We'll hear what they have to say, but they can't just put a blanket over everything and say, we can't tell you this. And this requires a certain amount of judgment that can then be appealed to they can go to court if they think we're really about to spill the beans, as they say, and they get notice of what's going to be kept confidential and what is not. Okay. And so I will move ahead to one of the, I guess, the question of adjudication here, because that is comes up when the agency itself makes the decision. We need to be carefully separating the investigative process from the adjudicatory process. When we are investigating, we're not, and then the agency itself will then decide. Well, then we stop communicating because we're not whispering behind their back as to what the outcome should be. It gets to the point that when we are at holiday parties, the staff investigating the case is in a different corner of the room for the commissioners because we respect it that carefully. There's right to presentation of evidence at every stage, representation by counsel, and we have to be careful that we are avoiding the perception that we are both the investigator, the judge, the jury, and the executioner, all wrapped into one. Okay, and I think that's the 7-minute version. The rest of it is available in the presentation.